Okay, so one of the things we looked at is that there's a common theme in these Supreme Court cases, especially in the last 50 years, where the argument was between the 10th Amendment and the state rights mentality, where anything that the national government is not allowed to do automatically needs to go to the state governments to handle. And that would be on one side, and on the other side, you have the 14th Amendment and the Equal Protection Clause. And that dynamic in the last 50 or so years, we looked at several different cases that used the 14th Amendment to overturn state laws on account of the violations of equal protection. So, for instance, we saw Brown versus Board of Education. Brown versus Board of Education is the case where the states could no longer make laws that racially segregated schools. These laws needed to be undone, and these schools needed to be integrated. So that's one use of the 14th Amendment. Then we saw in Loving versus Virginia, that was the case where Virginia had a law that prevented African Americans and white people from getting married. The Loving family, Richard and Mildred, had gotten married in Washington, D.C. They returned to Virginia, which is where they're from, and they were arrested for having violated this law and the cohabitation laws. They sued on account that this law violated their 14th Amendment. The state obviously said no, they're allowed to, because marriage laws were the exclusive province of the states. The Supreme Court disagreed that this law presented a violation of the 14th Amendment, and so these laws were thrown out and interracial marriage was allowed. Lastly, in 2015, we had Obergefell versus Hodges. In this case, just like many cases before it, the question was, 10th Amendment, can the states make these laws on their own? Or 14th Amendment, does the federal government have the ability to step in and make a change because of the violation of the Equal Protection Clause? And in this case, just like in Loving versus Virginia, the federal government said yes. This case had to do with states that were making laws banning gay and lesbian individuals from getting married. In Obergefell versus Hodges, the Supreme Court said the states could not do this any longer because it violated the equal protection. If you were going to allow a man and a woman to get married, it would be unconstitutional and unlawful to deny that ability, that right to two gay men or two lesbian women or bisexual men and women on account of their sexuality. That this would violate their right to equal protection and violate their right to due process. So those are three cases that deal with the 14th Amendment. Brown versus Board of Education, integrating schools. Loving versus Virginia, no more bans on interracial marriage. And recently Obergefell versus Hodges, which banned law or got rid of laws that banned gay marriages in the states.